Hello, and welcome to the podcast series, Creditors Corner Legal Talk, presented by Debnam Attorneys at Law, where we explore a range of legal topics impacting the financial services sector. Please be sure to hit subscribe so you never miss an episode. My name is Karen Lowe, and I'm an attorney in the firm's Consumer Financial Services Litigation and Compliance Group. I'll be your moderator today. Today's topic is title reformation and curative actions, and we'll be discussing defects in title which affect the title to real property and how they can be cured. Before we begin, I want to note that the information provided in this podcast does not and is not intended to constitute legal advice. Instead, any and all information shared is for general informational purposes only. Listeners should contact their attorney to obtain advice with respect to any particular legal matter. With that out of the way, let's now turn our attention to this week's topic. With us today is Jeff Rogers. Jeff is a partner at Debnam and leads the firm's foreclosure and real estate litigation practice. Welcome, Jeff.
Hello, Karen.
How are you today?
I am doing great. Hope you are.
I am.
What a very exciting topic we have.
It is an exciting topic. So today we're going to talk about defects discovered in recorded documents affecting the title to real property, how those defects are discovered, and how they can be corrected. So when we talk about that, the very first question I have just right out of the gate, and I'm sure our listeners also have it, is what are we talking about when we say reformation and quiet title?
Well, they're often used interchangeably, but there is some slight difference to them. Both of those are means in which the court can correct the title to a piece of real estate. So when you file a lawsuit to correct a title to real estate, and that's typically what you have to do, is to file a lawsuit and ask the court to declare something, to either declare somebody to be the owner of the real estate, declare somebody to have a lien on the property. And this is usually because there is something wrong either with the title to the property or with a particular document in the title. So when we talk about reformation and quiet title, reformation is actually correcting a document, reforming a document. And that document could be a deed or a deed of trust, but you're asking the court to change that document to reflect something else that it was supposed to have reflected to start with. Quiet title is a little bit different because the documents in the chain of title may be perfectly valid, but the way in which they are recorded perhaps might make the owner of the piece of property, we may call it into question. So quiet title is not necessarily changing or revising anything. It's asking the court to determine something, and usually that determination is who owns this property, who has a lien on this property, that type stuff. So reformation is correcting a document, and quiet title is having the court determine what the chain of title to a piece of property actually is.
So are these declaratory judgment actions that are filed usually?
They are. You're in either case, either reformation or quiet title, you are asking the court to declare something, either to correct a defective document through a reformation and declare that document did what it intended to do. And in a quiet title action, you're asking the court to declare that somebody either owns a piece of property or somebody has a lien on a piece of property. So yes, they are both declaratory judgment actions.
So when you get a declaratory judgment in those cases, do you then file it with the Register of Deeds?
You do. I mean, they're just two-step process. One is that you get the court to declare whatever it is that you are asking the court to declare, and then you take that judgment or that order from the court and record it with the Register of Deeds, and the recording of the Register of Deeds corrects the issue, the title defect of record.
Well, I know that this is something that you do a lot of, and I'm just wondering kind of what are some of the common defects that come up? Give me some examples of what's common issues that come up with a Reformation?
Well, they range the gamut. It could be a defective signature on an instrument. It could be a missing signature on an instrument, or it could be something as fatal as just the flat out wrong legal description on an instrument. So, and a lot of times, if it's a quiet title action, the documents are perfectly fine. But it may be that the way those documents were recorded with the Register of Deeds. Common defects, that it ranges from something that is relatively easily fixed to something that makes the document completely invalid. For instance, in North Carolina, if you have an invalid notary acknowledgement, the case law and the statute say that invalid, that basically means you have no notary at all. And if a document has to be notarized and you have no notary, that document is invalid on its face. So a lot of times we may see situations where it's a defective notary. The notary did not put their stamp, or the notary did not sign the document. In those circumstances, that is a fatal flaw that has to be corrected, or your instrument is invalid.
So are these things? These aren't things I think would come up in everyday life where I go, oh my gosh, I just realized we didn't notarize this document right. How do these normally come up?
Well, you're right. Most of the time, these come up when you have some reason to look back at the chain of title, or to look back at the documents after the loan is made. And that's usually going to be in two situations. One, if the property is being sold and a closing attorney is searching title for the purchaser, and in that title search, they determine that there is something invalid with the document, or something that makes the actual title to the property in question. Another way that it happens is when you have to foreclose, and that's usually when I determine those things for my clients. Loan falls in arrears. It's in arrears for 3 or 4 months, 5 months. Client decides to foreclose. They send it to me. I do a title update, and I determine that there is something wrong with a document in the chain of title. But you're exactly right. I mean, if neither one of those two things occur, you may never discover the defect in the instrument or in the title.
In the foreclosure context, does that hold up the foreclosure if there's a title defect? I guess the question is, what comes first, the chicken or the egg? Do you have to clear up the title and then foreclose?
Yes, absolutely. I mean, particularly if you're trying to determine whether or not you have a valid lien on the property. One of the things that you have to prove when you foreclose is that the lender has a valid lien on the property. And if that deed of trust is defective in some way, you're creating a defense to that foreclosure. So you have to go correct it. You have to go and reform that deed of trust to make it a valid lien on the property. And if you do that and you record that, then it's as if that deed of trust was valid from the time that it was recorded, because that's one of the things that you ask the court to do. And case law says that when a court reforms an instrument, they can reform it back to the date in which it was originally recorded. Because you got to remember, the courts the courts want to put people in the position that they should be in. The courts do not favor somebody being unjustly enriched or unjustly benefited by a mutual mistake of the parties. And so if a lender has a deed of trust prepared and prepares it for signature by a party, by a borrower, and for some reason or another, the notary does not properly notarize that document, that is a mistake that is mutual to both parties. And in a situation like that, the courts are inclined to correct an instrument so that it will reflect the intent of the parties to that instrument. The courts don't like people being benefited by mistakes. So if you can show to the court that somebody intended to grant you ownership of this property, or somebody intended to grant you a lien on this property, the courts are more than likely going to correct that instrument. But a lot of times you don't discover that defect until several years after the loan documents are signed. And that's usually because either a closing is about to occur or foreclosure is about to occur.
So it sounds like these are actions in equity. Is that right?
They are. Reformation is an equitable remedy. It is taking a defective instrument for whatever reason and declaring that and fixing that instrument to reflect what it was intended to reflect, and that is a equitable remedy that the courts use to make sure that documents that it's clear what should have happened, but for the mistake, that those documents are corrected, and that two people are not benefited by a mutual mistake between the parties.
Is this why people get title insurance, Jeff?
It's one of the reasons, yes. If you do discover, if a defect is discovered in either the title to the property or in an instrument in the title to the property, and you do have title insurance, and yeah, that usually falls upon the title company to fix that issue.
This kind of sounds to me like all this kind of falls back on the closing attorney. Is that right?
Well, it falls back most of the time, particularly if you're talking about a defective instrument, it falls back on whoever prepared that instrument. Now, sometimes it's a closing attorney. Many times instruments are prepared in-house by lenders. And unfortunately, they're prepared in-house by people who probably aren't as well trained as they should be, and don't understand the law like they should. I'll give you an example. In North Carolina, if you're married, your spouse has to sign any document that transfers an interest in property that you own. So let's say that a wife owns a piece of real estate by herself. She owned it before they got married. And then she marries her husband, and the wife goes and takes out a loan at the bank and pledges her property, her separate property, as collateral for that loan. If they're married, the spouse, the husband, has to sign that deed of trust. Spouse has a marital interest in the property, and if the spouse does not sign that deed of trust, then you have a defective deed of trust, at least as to his marital interest. A lot of people that prepare documents in-house don't understand these intricacies of the law. And if you were to have a deed of trust like that sent to me to foreclose, and I discovered that the spouse did not sign the deed of trust, that's got to be fixed before you can foreclose. So, and to answer a long answer to your question, yes, it usually falls upon the preparer of the document. And that preparer could be a closing attorney, but it's not always an attorney. Sometimes it is in-house, somebody that prepares those documents for the bank, and they may not quite understand the intricacies of the law, and they might not get it notarized correctly. They might not get it signed correctly. They might not put the correct or the complete legal description on the property. All of these things can make an instrument fatal.
So it seems like lenders get what they pay for sometimes. Is that a fair assessment?
Well, it is. It is. I don't know how to lend money, and most people at lenders don't know how to prepare legal documents, and that's the reason why there are bankers, and that's the reason why there are lawyers. And if I want a legal document prepared, I'm not going to go to a banker to do it. And if I need somebody to talk to me about the finances and the economy and how things work in the economy, I'm sure not going to go to a lawyer.
Fair enough. Any differences with quiet title actions as far as kind of how those claims originate?
No, same, but usually same way. The difference in quiet title is that usually it's an issue of how documents are recorded, in what order that they might be recorded. You could have, for instance, let's say that a lender is going to make a loan to somebody to purchase a house. And let's say that the deed and the deed of trust are going to be recorded simultaneously with one another because the loan is being used to purchase the house. And let's say the deed and the deed of trust were prepared perfectly. No problems, no errors in either one of those documents. But let's say, for some unknown reason, the deed of trust gets recorded before the deed. That's a fatal flaw because the deed has to be recorded first so that the borrower owns the property, so that the borrower can then give the bank a lien on the property. So let's say they get recorded in the wrong order. Then you would have to either fix that through some cooperation amongst the parties, or if you find that out later, years later, perhaps, then you would have to do a quiet title action and get the court to determine determine the ownership and the lien holder status on that property.
Jeff, any parting words of wisdom for our listeners on quiet title and reformation actions and how to prevent putting yourself in that position?
Well, just know that they can be fixed most of the time. And there are certain defects in certain documents and in certain titles that perhaps cannot be fixed. But for the most part, courts want to fix mistakes that are to avoid one party being unjustly benefited over another. So once you discover that there is an issue, it needs to be fixed. And I have a lot of lenders that will call me up and send me a foreclosure, want me to do a foreclosure. I will discover that the title it's something wrong with the title, something needs to be fixed. Then the loan is then brought current and the lender tells me to close the file. No, you don't need to close the file at that point. You have a defect in the title. You have a defect in your deed of trust. Irrespective of whether the loan is in delinquent or current, that defect needs to be fixed, because if the loan goes into arrears again, you're going to be dealing with this problem all over again. So if you know that there's a defect, if you have a question about it, let your attorney look at it. And if a defect is discovered, spend the time and the money to get it fixed, because if you don't, it could jump up and bite you one day.
Well, thanks, Jeff, for being here today with us. I know I've learned a lot, and I'm sure our audience has too. And thanks to our audience for listening. If any lenders or title insurers want to reach out to you with questions, Jeff's email is jrogers, JROGERS, @SmithDebnamLaw.com. Please check out our other episodes. We have another one on real estate and foreclosure related issues that's up from a couple months ago. And if you enjoyed this podcast, please subscribe. We appreciate all our listeners and appreciate your support. Thanks and have a great day.